Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here today with Doug Plass and Jennifer Walrath. And we're here today talking about employment agreements. Should you use them? Do you need to use them? Or would it just be better to stick with a solid offer letter that's got good terms and language within it? We're going to dive in today and talk about that a little bit more. So, to me, the biggest issue here with using employment law agreements is that we are located in Idaho, where we are an at will employment state. So, generally speaking, if you are an employee, you can be terminated for any reason or no reason, as long as it's for a lawful reason, as long as you're an at-will employee. But if you bring in something like an employment law agreement, that may very well change the nature of your employment relationship between the employer and the employee. And to me, that is one of the biggest reasons why employers should be very careful before they put an employment agreement in place. Anytime you have a document that starts laying out how long someone is guaranteed employment for, they start to look like they are not an at-will employee, and that can cause mischief in a number of different areas if something goes south with that employer-employee relationship. So let's dive in a little bit here. Doug, Jennifer, what do you guys think? Like, what are your general thoughts on the use of employment agreements?
Yeah, I mean, just kind of to echo what you were saying, I think it's one of these things that, employers kind of at first glance think they're pretty attractive. I want to lock this person up for a certain amount of time and make sure they stick around with me. I've made this investment in them. But like any agreements, both parties are obligated to do something under them. And I think it's risky for employers to just sign these things without really having a clear reason determined as to why they're doing it, because they're going to get themselves in trouble potentially.
Yeah, I was just thinking, I mean, you could easily imagine a scenario. You're onboarding someone, maybe a high level executive. You're really excited about them coming to work for you. They're excited to come work for you and take on the position. And everyone kind of is ends up doing an agreement with these rose-colored glasses on, right? This is a great relationship. We're all really excited about the prospects. You sign an agreement, and then within like a couple of months, it becomes very clear that it just isn't a good fit. The employer now is like, we made a mistake. We want this employee gone. But instead of being able to simply fire that employee, they may have agreed to something in the employment agreement that limits the reasons why, or maybe sets out, protocols or procedures that have to be followed before you can terminate an employee. I mean, there are all kinds of different provisions that may or may not be in an employment agreement, but you still agreed to something that governs the nature of the relationship, where you have to go and look at it and figure out what it requires and comply with it before you can actually separate this person from employment if you want to do it the right way. So all to say, it adds a layer in there that you have to satisfy before you can simply terminate someone. Sometimes employers forget about that and don't actually pull it out and follow it. Or sometimes they're like, you know what, let's just not worry about them. We got to get them out of here. And then you might run into issues where you've not done what you're supposed to do under the agreement. So kind of just piggybacking on Doug's and Pam's comments, you know, it can add risk, and it may not be beneficial enough. And I think oftentimes too, when people sign them, they just aren't always thinking about the possible ways that things can go south, because human nature is, maybe not to think about the way things can go badly and to be looking forward to the positive aspects of onboarding someone who, you're hoping can add value to your business.
Yeah, the one scenario where I think, based on, looking at these over a number of years, where it might make sense to use an employment agreement could be if you've got a high level executive, like maybe you've organized a search committee and you're looking for a high level person who you're going to bring to, your place of employment. Maybe they're coming from another state. Maybe you're paying relocation fees. Maybe you've made a big investment in this person on the front end, and you're going to disclose to them a whole bunch of confidential proprietary info to get them up and running. That might be a scenario where it makes sense to have an employment agreement, where you've got an agreement, a commitment that they're going to stick around for a period of time in this role that they have come to fill. So to me, if you have someone in that role, okay, maybe you could convince me that an employment agreement is a good option. But sometimes we see employers who want to give employment agreements to every employee. Maybe they want to do it so that they've got a place that reflects the agreed upon salary or their primary duties, that type of stuff. And to me, that might be better info found in an offer letter and in a job description that in a separate employment agreement that might impact that at will employment relationship that is so beneficial for employers to have. Jennifer was talking a little bit about one of the things that is probably to me the most important term in an employment agreement, which is the conditions that would trigger dissolution of the agreement. So when can the employee leave? When can they terminate the agreement? When can the employer terminate the agreement? Or what happens if everybody's in agreement? This isn't working out. We should end it. 100%. That is what causes the most trouble. And in my experience, triggers claims most frequently is if you don't have it clearly spelled out who can terminate and when. What happens if you've got a 2-year agreement and 6 months into the first year, the employee wants to terminate or the employer wants to terminate their employment? That is the perfect recipe for a lawsuit.
Yeah, I was just thinking as Pam was talking, I got a little bit ahead of things, but even once you've decided that it makes sense for a business reason to have an employment agreement for someone, then to go through the exercise, which again, like I said, I think it's kind of uncomfortable for a lot of people, is envisioning the possible end to make sure that what you have in your agreement um, is done. You've done the best job you can of covering your bases, and it's difficult to be 100% on those kinds of things. And no one's prescient, no one can see into the future and know exactly what will happen. But to really think through how are the various ways this could go south, and if it happens that say someone wants to leave, how much notice do I want? Uh, Are there certain grounds that I want very clearly set out that if this happens, I have the right to terminate you? Do you want the employee to be able to leave on their own? And what does that look like? Are there, processes in place? How much notice do you want? And all those kinds of things, right? Are sort of the fundamental, I think, provisions you need to think about for sure. Other things might be, if someone how do we handle confidential information and making sure they understand they have to give it back when they leave? You could have provisions like that. You could have, if they're legal, non solicitation or non compete provisions. So, thinking through some of those kinds of things, right? Like after someone leaves, do you still want them to have any continuing obligations to the company? What do those look like? And how do you make sure they survive, right? Whatever happens with the employment. So, a lot of those kinds of things. Again, I think it's hard to think about the end at the beginning, but with an employment agreement, that's really what you kind of have to do to make sure that you've done the best job you can. And I think it benefits both the employee and the employer for that exercise to happen.
And as you were just saying that, it got me thinking about, for high level executives, kind of the advantage of using for high level executives is they tend to be engaged and have counsel and actually help you figure out what the terms of the agreement should be by arguing with you about them, for instance. So like that's actually helpful in terms of coming to an agreement that's going to work for everybody. But one of the things we're talking about important provisions, And we've seen a number of agreements where it'll say something like, termination can only be for cause. And then nowhere, anywhere is what constitutes cause for termination. And, we've had to make arguments that like, hey, well, if it's anything that's in the employee handbook, that, defines something as conduct that they shouldn't be engaged in or performance that is inadequate, then that constitute cause. But it's a lot better if, the agreement itself actually says what are those things that constitute cause for dismissal, because otherwise you just end up with the lawyers arguing about it and you don't have any clarity.
Yeah, those are really good points. I love Jennifer's envision the end. It's like so ominous, right? But that's what we do every day. That's what employers do. If you have trouble getting there, call us because we're the compliance people. We get paid to like think about what happens if this thing goes south. And that is really the most important thing you can do because you really need to think through, like Doug said, you can't have this vague language. For cause to me is very vague. And if you haven't defined it in the agreement, it's going to cause problems. Like, what do you mean by for cause? Sometimes we see, I love Doug talking about the notice provisions. That for sure comes up. How much notice are you going to require the employee to give? How much notice do you have to give? Sometimes we see too, not just notice, but an opportunity to cure. Like, are you going to put in there that if somebody's made a mistake, they need to have notice that you think they're making a mistake and not doing a good enough job? And are you going to give them a chance to fix it or not? Those are all things that you might include in there, depending on what type of industry you're working in. But for sure, don't just throw in some phrase like for cause so that that's what, whether or not a termination of the agreement can happen or not hinges on. That's exactly the type of stuff you have to think through.
Another thing that came to mind as Doug and Pam were talking was, does the agreement automatically renew? Is it have to be intentionally and specifically renewed, as in you have to make a new agreement? So, for example, I mean, you can pick your term for the agreement, 1 year, 2 years. I think if you get past 2 years, that's getting pretty lengthy. Maybe not the best idea. But let's say you have a year-long employment agreement. What happens when that year is starting to come to a close? Some agreements will say it automatically renews, but that can lead to some tricky issues sometimes as well, where maybe people just kind of proceed as though it is an at-will employment situation, but really it's not, because there was an employment agreement in place at the very beginning that governs how that relationship operates and how it ends and things like that, right? Or do you specifically put in there, it may be renewed, and kind of lay out the mechanism for how that's going to happen? Is it like an addendum, or how does that work? So kind of thinking about that, right? Maybe you have somebody, things are going well, you want them to stay. What does that look like in terms of continuing that employment arrangement?
Yeah. And another issue that comes up that you just triggered as you were talking is it enough for you just to say in your agreement, the at-will employment relationship continues despite the fact that we are now putting in place an agreement for a definitive period of time, whether it's 1 year, 2 year, whatever. We see that a lot too, where people put the language in at will continues. I would argue it doesn't. To me, if you put a period of time in that agreement is in place, there is a definite legitimate argument for someone to make that the at will employment relationship ended. And Jen, I'm going to like piggyback on what Jennifer said too. To me, 1 year is probably the sweet spot. I start getting nervous when I see employment agreements for 2 years, especially with a new employee. You just have no idea what type of issues are going to come up during that time, what the economy is going to do, what their performance is going to look like, what your business looks like. Sometimes we see agreements for 3 years, 4 years, 5 years. To me, that is very dangerous. I would not do that.
Yeah. Although I think that for some employers, for these high level folks, kind of some longer agreement that is more like, if you stay for this amount of time, then here's what your exit package will look like. That's a little different than an agreement for a specific duration. It just kind of defines the time periods at which certain benefits will kick in. And I think that's a little easier to manage than something like a 3-year agreement forever, you know.
Yeah, I was just thinking through, a lot of these agreements do set out the compensation in the agreements. I suppose you might be able to figure out a way with the agreement to kind of, adjust compensation outside of the agreement. But again, all things to think about, and kind of circling back to Pam's original comments, right? I mean, if you're hiring someone and the primary thing you want to set out is just the terms of compensation, that looks a lot more like an offer letter. We'll get it done for you, where you just explain, here's what we're saying we're going to pay you. You understand that. And, here's going to be your first day, maybe some information about benefits, things like that, right? That you're full time, part time, whatever the particular position is. If that's all you really need, I think that would weigh in favor of considering just a simple offer letter and not going to the effort of going to craft a thoughtful employment agreement.
Let's shift gears a little bit and talk about confidentiality provisions, non-compete provisions, non-solicitation provisions, and how those play into employment agreements a bit, because we do see those a fair amount of time, where someone has signed a non-compete in conjunction with employment, and then down the road that ends up getting litigated, whether or not that's enforceable. So what do you guys think about that?
I honestly would say a lot of our litigation over employment agreements has been about those kinds of provisions in the employment agreement, right? Did you comply with your continuing obligations once you left? Did you comply with them once you still worked for us? And if you didn't, then you breached the agreement. So certainly we have, I think, seen a lot of fights about those kinds of provisions in employment agreements, which circles back to, if you're going to have them, draft them carefully. I will throw out also, though, that sometimes you can have employees who you've given offer letters sign separate agreements that are specific to, say, confidentiality, right? So you could give an employee an offer letter that sets out their compensation terms, but then separately have them sign a confidentiality agreement, where they say, I acknowledge there's confidential information. I agree that I will not disclose it while I work here. I won't take it with me when I leave, and I will not disclose it to anybody, even if I do have it after I leave, things like that. For non-competes as well, if you have sufficient consideration, right, meaning it's a fancy lawyer term for the employee has given you something, or you have given the employee something in exchange for them agreeing to things like not competing after they leave. I would say probably here in Idaho, generally speaking, if you have paid the employee for the time that they have worked there, that's generally considered sufficient to have those kinds of provisions in place, provided the employee otherwise checks the boxes for the kind of employee that you can subject to a non-compete limitation after they leave, which we're not talking about those today. But I guess that's a very long way of saying you can have those kinds of provisions in place with an agreement that's an employment agreement, or separately with an offer, and just figure out how it makes sense for you to build that. But if you have them in your employment agreement, you certainly can have them in there if they otherwise comply with the law. And then again, just kind of going back to think through how you want that to look and make sure it is compliant and enforceable if you put it in the agreement.
Yeah, and like Jennifer mentioned, we have certain requirements in Idaho. Different states are all over the place with regard to these things. So make sure that you pay attention to where your employees are located and what state law will be governing them. And another thing that came to mind is, these types of things, confidentiality agreements, non-competes, non-solicitation agreements, these are the types of things that employers want to survive the employment relationship. So you really need to make sure that you have language in your agreement that spells out that even though these other things in the agreement having to do with, what you can be terminated for or what your pay is or whatever else is in there, might end with the end of the employment relationship, these things do not. And that's part of the reason why some consideration is required for them, as Jennifer was mentioning.
And another thought on those same lines, if you're going to incorporate a non solicitation or a non compete type provision into your employment agreement, that's another reason to maybe revisit your employment agreement every year, because what we know is the law is changing on non competes, non solicitation. We know that last year in 2024, there was an effort to try to make non-competes void altogether. So what you don't want to do is have an employee come on board, put a non-compete in their employment agreement, have a provision in there that says the agreement automatically reviews, and then not revisit or update your employment agreement for years and years. Because if, for example, the law changes, that could be a problem for you. Or, like, what if the employee gets promoted and moves to a different position? That could be a problem for your non-compete too. So, very important to make sure you're keeping an employment agreement updated if you're going to have provisions like that in it, and that you revisit them from time to time so they don't just sit in a personnel file and become old and obsolete.
I agree, and I was just gonna throw in there, I mean, I think probably listeners can tell from our discussion today that drafting one of these is not necessarily the easiest. Like, I'm sure that there's probably places to pull down, template employment agreements. But I think this really is one where if you choose to use them, it is a good idea to get counsel of some kind to weigh in on the agreement, because there are a lot of, I would say compliance, or just do we have an enforceable contract type considerations that need to be thought through. And those are just the kind of things where, kind of we do every day, other lawyers do too. Um, Choice of law, if a claim happens, where are you going to litigate it? Um, just a lot of different issues to consider to make sure that what you have in there, at least at the time that it gets signed, is enforceable. If you're going to renew it after a year, revisit it, go through that again, because you just don't want to be in a situation where there's any question as to, well, can you as the employer enforce provision 5 because provision 4 isn't legal anymore, for example, or never was, even when it got first signed. So just to kind of get your ducks in a row, make sure that what you have in there is going to be enforceable under the law is very, very important.
Yeah. Yeah, that choice of law piece can be a big deal. We're in Idaho where non-competes are legal. But say that you have an employee working in California, that would be one example. You certainly don't want, to be putting in place an employment agreement with a non-compete without getting counsel to take a look at that and make sure that's something that's going to be enforceable. So today, I guess, as we wrap up, we've talked about a lot of stuff, but we've talked about employment agreements, and then maybe even how things like your handbook, your offer letter, job descriptions, maybe standalone confidentiality agreements, standalone non-solicitation or non-compete agreements. Those are all tools that could help you achieve your goal if you're thinking through something like this. Maybe you don't want everything wrapped up in one employment agreement. Maybe you want to use the offer letter and some of those other tools as well. So just putting in a little plug there, those are good things to make sure you've got them on hand and that they're updated. And if you haven't recently, that maybe it's time to pull those out and get that done before too much more time goes on. So that's it for ground rules, employment law over your coffee break. As far as what we've got going on over here, we have a busy fall coming up. We have a workplace investigation seminar coming up on September 25th. If that's something that you feel like you would like to learn how to do better, or maybe you have questions about what goes into the report or how do you conduct interviews, we would love to spend a half day with you on September 25th helping you work through that. We have our book, Law for Leaders, the roadmap every leader needs to follow to avoid workplace claims and lawsuits. That's a great tool to have at your disposal on your desk, too, in case some of these issues come up. And then we have our Law for Leaders training. We've got a host of recorded content, live content, and pretty much everything in between to make sure that you've got the training you need to stay out of court. So that's it for today. We'll see you at our next episode of Ground Rules. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.